I just got a message from Chairman Ballinger. They were still caught up in a caucus meeting, and they will be here shortly.
Okay, ladies and gentlemen, we'll go ahead and get started. Unfortunately, we had some various meetings that met upon adjournment that have taken us over the allotted time. Do apologize for getting started late, but we are going to go ahead and get started. We're going to hear House Bill 913, and it is for hearing only. So we're going to turn it over to Representative Reeves.
Thank you, Madam Chair, and thank you, members of the committee. Just as I'm going to give an overview here, and then we can walk through. I've got some technical experts here with me, but as most of you that are up there recall, a couple of years ago, we passed a big adoption code rewrite, and what this bill is 98% of it is what we would just kind of generally refer to as a technical cleanup after passing a major overhaul. There were a couple of things that were, a couple of errors that weren't caught. There's some things that could be worded as this has played out in court over the last 2 years. We've seen that there are some things that could be worded better that would provide clarity, and that anytime we are able to provide the courts and litigants clarity, then we do well. Especially, there's some provisions in here about certified mailings and things like that. They're just taking what we did a couple of years ago and refining it and making it better and a little more user-friendly. The only real significant policy change from this bill as it relates to current law is in Section 2 on line 30, changing the minimum adoption age from 25 to 21. And I will say that if you were in the House in the prior term and you voted on this bill, which it passed unanimously all 3 times it came through, then you've actually already voted on this provision. This was something that was through the compromise and work with the Senate that was changed back to 25, and so and obviously we have fully prepared to defend the reasons why we still believe that that's that's landing at the right place. But this is an extremely technical. It's long because kind of the second half of the bill or adoption is a very form-based procedure. There's lots of forms, and so the forms are all codified. So a lot of these simple changes are just cleanup language and clarification language is going into the form, so it's not nearly as, for 36 pages, it's not nearly as long as it may seem. But with that, what I would like to do is introduce Justin Hester, who is an adoption lawyer up in Gwinnett County and who was one of our key testimony persons in the rewrite a couple of years ago. And also, everyone here, I believe, knows Melissa Carter from the Barton Clinic, who is also here to help testify on some of the provisions. And so we haven't really discussed this, but do you want to walk through the summary, or do you? Want to flip a coin? Madam Chair, is that okay if we proceed just by kind of going through section by section?
Yes, it's your bill. So.
Sure. Okay, great.
Why don't I'm happy to walk through the summary. If
Okay.
you have any questions about
Okay,
it?
that's
How would that
perfect.
be? Good afternoon. As Representative Reeves was mentioning, it's really the first half of the bill that actually make the changes to the statutory provisions. All of those changes are then brought forward into the forms that reflect the practice mechanisms for those statutory provisions. And I believe you've been provided with a summary that's a few pages long that walks through section by section with a brief description of each change. So that's what I'll refer to. We prepared that hopefully to help facilitate this process of walking through these changes. And then I know Justin will help with any sort of practice implications. I'm not currently in adoption practice, so we'll rely on him for that perspective. I'll just start at the beginning if that's what you'd like, and then you can interrupt me if there are additional questions, and we'll make sure you get the answers that you need. So there at section 1, I'm specifically looking at lines 18 to 20. This is a change to the adoption venue requirement, so the place in which adoption jurisdiction rests. that generally requires, as you know, an adoption practice that the petition must be filed in the county in which the petitioner resides. There are some alternatives to that default, including to be a venue where the child is placed for adoption with an out-of-state resident. This provision, let me turn to actually the language in the bill so I can zero in on it. The language that has actually been added there at lines 18 to 20 really speaks to clarification that comes from the adoption revision that we were just referring to a few years ago, where courts have needed more specific direction with respect to when the interstate compact on the placement of children does or does not apply. So when children are placed out of state, that implicates this interstate compact. There are, however, provisions within the ICPC that are exceptions to that really render it sort of irrelevant. And so the courts were looking for some additional direction. Justin, is there more that you would say about that?
Just unless anyone has any questions about it, it's pretty technical. It was just a clarification that sometimes the interstate compact does not apply, but those non-residents still have the ability to finalize their adoption in Georgia.
Section 2, then moving on to the changes at lines 30 to 31. This is this provision that Representative Reeves has already mentioned, reducing the age for the petitioner for adoption from 25 to 21. That is now consistent really with the national trend and is otherwise appropriate. The strikeout then that you see really because once we make a universal age of 21 for the petitioner, we no longer need that caveat that reduces the age when we're talking about a relative adoption. So that is just sort of conforming the provision then as would be required. And then at lines,
I want to add to that too. I mean, just from experience, and one of the things that became a hang-up in the Senate on this, as you all are aware, there is a very, very rigorous, we put in law these things all day long, but there is a very, very rigorous judicial eye that goes into every aspect of this with the best interest of the child. And while probably most 21-year-olds are probably not ready to adopt, some are. And knowing how the judicial process works throughout an adoption, I have total confidence that a judge can make that decision on when a person who might be 21 or 22, it wouldn't be in the child's best interest. So,
still continuing then in section 2, lines 35 to 42. This is again similar language to the one we just covered with respect to when the ICPC does apply or doesn't apply. It's for the same purpose, to make sure the court is clear that you are in compliance with this interstate compact even when it doesn't apply. Justin, I didn't know if you were, I'm sorry, I thought you were going to say something, trying to anticipate. Moving forward then to section 3, this is a striking out of a previous reference to subsection A, just to clarify for the courts, particularly courts of review, to make sure they're zeroing in on the right provision. After the code was revised, that no longer is the level of precision that is relevant for that reference.
so we'll just call that cleanup.
Let's call that cleanup. You'll see that there are other places where you will see that, of course, as we continue. Section 4, lines 88 to 92. This is, again, clarification when we're talking about the surrender for adoption and the revocation, then the time period that is allowed for the birth parent to rescind that surrender. This clarifies that the deadline for that is actually midnight on the 4th day. So again, for some precision purposes, because there's such a significant right there that we're talking about. So precision matters. Section 5, to just continue. Lines 102 to 103, 109, 118, and 124. This is all language where you see the insertion of references to certified mail. This is about the service, of course, on a parent when state law does, in this provision, when state law does not require a surrender or termination of parental rights. This use of certified mail was something that historically has been true in adoption practice, even when I was practicing in adoption some years ago. It was actually removed when the adoption code was revised, and it either inadvertent or discovered that there actually is a need to use certified mail so that the costs of adoption aren't unnecessarily increased by requiring registered mail or personal service. So this is a little bit of a restoration of what was always true before and never necessarily problematic before. So we're kind of picking that back up. Section 6, lines 133 to 134, 140, 149, 155. Similar here, you'll see those references to certified mail, same purpose, same policy intention there to restore that practice opportunity. Let me say more.
Briefly, with the bill a couple of years ago, my understanding is that Legislative Council wanted consistency throughout, so changed all the certified mails to registered mail. The purpose of using registered mail was only for the purpose of a birth parent revoking their surrender of rights, because registered mail actually shows when it's tendered to the post office. That's when the surrender revocation has to be tendered within a certain amount of time. Doesn't have to be received within a certain amount of time, but it does have to be tendered on the fourth day at midnight or earlier. And so we wanted to change certified to registered, because certified does not show when you actually gave it to the post office. Registered does. In all the other cases where we're using certified mail, they're very similar, but certified mail just shows when it's received, and it's imperative to know when it's received in all these other cases, if that makes sense.
So that's a great segue into section 7, where you again see the insertion of these references to certified mail for the purposes Justin just described. Also in section 7 at lines 182, 190, and 216, you see their recurrence of this deletion to subsection A, cleanup we talked about before. So then quickly moving on to section 8 at lines 260 and 264. This here again is cleanup from this comprehensive overhaul to change the reference from code section to subsection, again, to make sure that we're making that cross-reference correct and accurate. Lines 283 and 304, again, here we're providing just greater specificity by specifying Chapter 4 of the Interstate Compact on the Placement of Children, which of course is a comprehensive act. We really want to focus, the relevant part here is on Chapter 4. Lines 218, 310, 330, 390, again, the deletion of subsection A. Lines 409 to 410, this is with respect to the putative father registry search that's required. So when you're filing a petition for adoption, you attach a certificate that says that the putative father registry has been checked to see if any unwed fathers have indicated that they might be a potential father who might then have a prospective interest and need to then have due process with respect to the adoption filing. And so this is, I lost my place. This is restoring of previous law unintentionally omitted with the adoption code revision, as I understand it, which allows for that search that I just mentioned and that certificate to actually be performed and attached to the petition as of the date of the petition. So you can do it before then. You want the most current results, of course, and so this is just saying you can do that as of the date the petition for adoption is filed, to make sure you're aware of the most current status of any unwed fathers. Section 9, lines 424 to 427, this allows, really sort of puts the responsibility on the petitioner for adoption to request this appointment of this investigator who's going to do the verification of the allegations in the petition. That is something that is actually an obligation of the court. Here, we're just kind of putting a backstop to that to say if the court doesn't do it on its own like it's supposed to, the petitioner needs to initiate and make that request so that that process happens and we have the benefit of that ferreting out of the allegations. Lines 430 to 431, still related to this investigator's report, allows for the investigator's report to be factored into as part of the timing considerations for setting the final adoption hearing. You want to obviously have those results back before you have the final hearing, the decisions of which turn in part on that kind of information. Section 10, lines 440 to 442, allows the adoption petitioner to suggest names to the courts of people who are qualified to serve as this court-appointed investigator. Again, an efficiency here in the sense of there are certain people known who are qualified to do that kind of work. The petitioner may be aware of someone already and be able to present that to the court on a home study. Yes, to be clear, the investigator on the home study. Thank you. You see the lines 452 and 453. This is the striking of the reference to subsection A we've covered. Lines 465 to 466 and 478 to 482. This is a new provision. To be honest, I'm gonna be real. I don't know if I don't want to speak for the sponsor. We're still sort of working through this at some level. There has been a longstanding interest to make sure petitioners for adoption are not burdened by the financial costs of having to obtain a fingerprint, criminal records check. When there is one already available. So as currently structured here, this creates an exception to the required fingerprint history for petitioners. Oh, I'm sorry. This is the same thing, right? Sorry, I thought I was getting ahead of myself. So first of all, it creates an exception for that criminal records history check when we're talking about really just domesticating a foreign adoption. So foreign adoptions are finalized abroad in Georgia. You don't finalize the international adoption here. You just domesticate the order so that you can have a U.S. Georgia birth certificate for purposes of acceptance at schools and otherwise, where it's a little more familiar. But what you're doing is actually, as a legal matter, domesticating that foreign decree, reducing it to a court order here. And for adult adoption, so where a person's adopting someone over the age of 18, so we wouldn't have to have that criminal history check in those instances. And this is the part I was sort of flagging so I got ahead of myself a bit, that allows for this an affidavit from the Department of Human Services Division of Family and Children's Services to satisfy the requirements for a criminal background check to prevent then the petitioner from having to obtain a new one at their own cost. I believe I understand that there are lots of complications around that fingerprint check, and so I think there is some inquiry into the federal limitations on whether something could substitute for that. Is just to be more full disclosure about where I was, what I was signaling for you. Section 11, lines 513 to 517, as you can see, creates a presumption that a non-resident petitioner, someone, of course, who lives outside of the state of Georgia, can appear for the final adoption hearing electronically, right? So some efficiency, making use of technology and not requiring a personal opinion or a personal appearance when the petition is uncontested. So when you have a very straightforward adoption matter that otherwise would proceed in the judge's chambers, and we'd walk through the statutory requirements, and we'd find ourselves at the adoption finalization. 527 is another one of those subsection A changes. 559 to 563 clarifies that the court has the authority to determine adoption based on the standard of best interest of the child, which is the prevailing governing standard, in adoptions of cases of children born in a country other than the United States. Justin, you might want to fill some in on that on the international adoption side.
And this really is just rephrasing. I mean, am I wrong? It's rephrasing.
No. It's a clarification. I think there's a boatload of adjudicated law, case law that sets this out. It's just codifying it. It's also a best interest standard. So I do want to just back up for just a second. I'm sorry, Melissa. Where it was? Yeah, can I see that for 1 second, Cass? Sorry. Let's see. There were two parts in Section 10, the criminal history affidavit being substituted. That really is, I understand that there may be some federal issues there, but that really was just the goal is really reducing costs, particularly for foster families that are adopting, because they've been fingerprinted. And the problem is we're having to have them do that again at an additional cost where they've been fingerprinted by the state already. But those, we just can't, they won't release those results. So that's where that came from. But I did want to clarify that the other issues in that Section 10 are non-controversial. So just not to correlate those two things, those are cleanup matters as well. So did I answer your question about the international? Okay, sorry.
So we're now at section. Thank you. We're now at section 12. And I might turn to Justin a bit for this as well. The request from the adoption lawyer community was to, as you can see, lines 584 to 589 and 594 to 597. This would add a new subsection. The concern here is around, unfortunately, sort of some scam type conduct or scenarios where individuals are intentionally misrepresenting that a pregnancy exists or that a child is available to be placed for adoption. When the individual, in fact, not either pregnant or doesn't have an intention to place the child for adoption. The difference here that's covered in some ways, that kind of, if you will, not sort of well understood scenario, is covered in some ways in our other laws. Here we're actually talking about a more limited situation where actually no money is transacted, so that the harm, if you will, is really one on sort of the emotional level, but doesn't have that sort of economic harm that our other laws account for in their design. I don't know if Justin, maybe that's a good time to turn it to you.
Yep. So the two additions here are kind of two different issues, or related but different issues. Starting at 584, this new section 4, this is a little bit of an expansion of what's already in the code, and we really do see a problem, and I think probably an increasing problem. A lot of it has to do with the people finding each other online of fraud. And this additional section, with the last adoption code revision, there were some provisions included that criminalized certain behavior, basically taking money from either agencies or adopting couples or prospective adoptive couples, in working with multiple couples or agencies, and then not placing. Now, I do want to make sure everyone knows a birth mother or a birth father who's placing for adoption that is certainly can receive expenses and then change his or her mind. No question about that. This is if it's intentional, but 4 is an expansion to include the specific instance where there was no pregnancy to begin with. We're just seeing more and more of that, where someone is saying I'm pregnant and begins a relationship. A lot of times they're in multiple states, and taking expenses over the course of several months. It could be thousands of dollars, and then it turns out that they were never pregnant in the first place. So that would fit under traditional fraud, but this actually provides a more specific remedy for adopting parents or adoption agencies that go through something like that. I can tell you that recently, 2 agencies that I represent in 2 different states, along with 4 other agencies, all of which, and when I say that we're talking, these are people, these are couples that are hoping to adopt, that are working with the agency and paying these expenses. One birth mother here in Georgia received funds from all 6. So it's not uncommon. So just trying to tighten up and provide remedies for people that are dealing with this. I think we're going to see it more and more. The second edition, starting at 594, this one's this is probably a little bit more difficult to articulate, and I'm not sure it's articulated great here, but there are also people out there that do this that don't receive money, but that for some reason seem to get a kick out of breaking someone's heart. I know that sounds strange, but the BBC actually had a series about some of these folks, and they will lead on people about a potential adoption, and again, it may never even be a pregnancy, but certainly there's no intention to place. And so there are situations that happen where there are no monetary damages, but where people are misled, and so the idea was to provide some ability to prevent that from happening, or to potentially there'd be a punitive element if you do.
A deterrent also to any actor out there that thinks that that's appropriate and that they can get away with that at no cost.
I'm sympathetic to that. However, if we have kind of an overwrought teenager who may be post online, oh my God, I'm pregnant, and there's no specification for exactly, monetary exchanges, and people in these situations, as you're well aware, are very overwrought. Yes. They're very emotional. And so my concern was that, they would retaliate, and the girl, through no fault of her own or no desire to mislead the couple, or, whomever is adopting, creates this, and suddenly, she, in a month or so, she comes to find out that she is not pregnant. So that's kind of my concern there. And there's no, like I said, there's no specificity. It's not like she's accepted a lot of money from them, but because there isn't.
I do think that there is a difference between accepting money and doing it. This is happening. I don't want to underplay that. This is happening, and it seems to be happening with more regularity. But I do agree that this is a hard one to articulate.
Mm-hmm.
That would.
There's no bar. It could be punitive. You crushed my hopes. I decorated the nursery. I'm very angry at you. So that would be a concern. Representative Hutchinson.
Thank you, Madam Chair. I have to agree with you. I have the same concerns, and when you talk about someone who's doing this just because they enjoy crushing people, that's a mental health diagnosis.
Could be.
And so in that case would be punishing a mental health diagnosis. So that would be my concern as well.
A tortfeasor, I'm not going to argue with you, but a tortfeasor behaving in conduct that might be a result of mental health doesn't cure a tort, though. I mean, we're not talking about criminal liability. This is civil liability.
I get that. And also, right now I have a constituent whose child was at an inpatient facility that horribly mismanaged his case, but there's no remedy for that family because there's no physical damage to the child. So that would be kind of the same thing. So if we're going to do something like this in this situation, then it feels like it opens the door for everything else.
And as a lawyer, proving intentional infliction of emotional distress is probably one of the toughest tort concepts that exist. My feelings are hurt. That doesn't cut it. You have to be able to demonstrate a track record of medical psychological treatment, et cetera. This is not something. While it very well may oftentimes be pled in a lot of lawsuits, very rarely results in actual award of damages. Oftentimes it goes away at summary judgment. Probably 8 or 9 out of 10 times. That's just a reality of the burden of intentional infliction of emotional distress.
So then why would we need it if you don't use it?
Well, I would say that the goal or the goal of this was to include that as an option for a remedy. Again, it's still going to comport with everything you have to prove, and Bert's right. Emotional distress is a really difficult high bar. I will say this: the folks that we were, or that the real life situations where we're talking about that led to this are recidivists. They do it over and over and over and over again to couple after couple after couple after couple, or agency after agency. And so these are patterns that where there's again, it's trying to find some deterrent to people.
But you
that are
said
doing
earlier
this.
that a lot of this will fall under current law for fraud, correct? And that's something that clear. If it's recidivism and it's over and over and over again, it would be covered by current law.
It depends.
For fraud?
We're specifically.
Fraud, I mean, I don't want to get into a discussion on the elements of torts, but the elements
Certainly
of
not
fraud.
with a social worker, you don't.
The elements of fraud is a totally different concept than intentional infliction of emotional distress. You can't talk about while somebody may inflict emotional distress in the perpetration of a fraud, they're not one and the same. And so this is, and again, this is a hearing only. We are more than happy to take this offline. I think let's take a step back. This is directed at a conduct that we've seen. Just because this cause of action isn't successfully pled the majority of the time does not mean that there are not specific circumstances that absolutely call for this tort. And I think that what the Georgia Council of Adoption Lawyers is saying is that this is very pointed to this particular issue that we are seeing happen, and correct me if I'm mistaken, seeing happen at a more frequent rate now for whatever reason.
Certainly.
It's
We will see more of this on both sides. Again, I think the taking of funds and with no pregnancy or no intention is a problem we dealt with for a long time. But this is something that does exist. It doesn't create any presumption or anything like that would give rise to a specific newly created tort. Again, I think the goal was just to say that this would be an option if you're dealing under this in an adoption setting. That I think you could do it anyway. But again, so much of this is clarification and trying to make things less ambiguous. It's just adding an additional, avenue for a potential remedy in these kinds of situations. They are obviously highly emotional circumstances, and people can point fingers a lot, but it wouldn't increase the likelihood that a judge is going to find that this occurred. You'd still have to meet all the elements of a very difficult tort anyway.
Yeah. The language about when you're pregnant, when you're not pregnant, what is the bar for that? What if you're in the middle of rural Georgia and, I guess it's different if you have the resources to go to a doctor and get a blood test versus if you're in the middle of somewhere where there's no OBGYN. Proving pregnancy, it kind of feels a little icky to the social worker over here.
Just to clarify, asking about the fraud on the financial side, where someone maybe thought they were pregnant, turns out that they weren't pregnant, and was working with a couple or an agency or something like that, and then found out later. I think there's an inherent good faith aspect to this. So if there's let's say a young lady that believes that she is pregnant and starts talking to someone about placing for adoption, turns out that she's not, I don't think that would fall into any of these categories.
It's not intentional misconduct if they're mistaken, and the burden of proving the intentional misconduct is on the plaintiff, the person that would be moving for. I mean, that's part of their burden of proof to establish this cause of action and the elements of this tort is that it was intentional conduct, and if somebody is mistaken, then there's no foundation for that to move forward on.
Okay, all right. Thank you, Representative Collins.
Representative Reeves, thank you for bringing this, and I want to understand this. If we leave that in Section 12, it's just another tool that could possibly be utilized to help address that issue that's continuing to be ongoing and, in your opinion, getting worse?
Yes, it's just a pointed effort, and if we have missed the mark in articulating this the best way possible, then we will work on that, and we can go back to the drawing board on more specific language, whatever if the committee is more comfortable with. Our job is to get this perfect,
Right.
And if this is not there, then that's something that we'll go back to the drawing board on. But this is, again, we are part of our job in the legislature is identifying, a lot of the things, a lot of the problems that are going on in our state in all these different areas, and and figuring out how to address those. And part of it creates an accountability, and the other part of it hopefully creates a deterrent.
Right. I see this as a positive because there are probably a lot of people out there who would like to try the adoption process, but they've heard horror stories of things, and they've already in an emotional state. Maybe they can't have children of their own for whatever reason, and the adoption process is that final hurdle that they need to fulfill that dream of having a child. But because of that emotional state, they don't want to get their heart broken again. And so I see that as a very positive for the bill.
Something I learned a couple of years ago, or I guess 3 or 4 years ago is where it started when I first got involved in this process. The adoption serves a lot of purposes, and a lot of the times it's for a person or a couple that are not able to have children, and the emotional the emotion behind that is probably registers just about as high on the scale as anything. And when something goes wrong, when they move forward and take this step, and something goes wrong, as their hope for expanding their family is placed in this, and something goes wrong, the trauma that comes with that is just as significant as the hope that was with that, as for what they hoped to expand their family from. And it is, from the conversations we had years ago, the families that adopt, and then within the revocation period, they take the baby home, and then they have that time period where the baby can be taken back. I talked to parent after parent who said that they were afraid to bond with that child until that time frame was up, because they were so scared of knowing that if something that's out of my control happens and the revocation of termination occurs, or surrender, occurs, that the fear of the emotional damage that would just naturally come with that. And so, this is very, very, very emotional stuff, and I think everybody recognizes that. And this is an attempt to identify something that we can point to and present an answer to it. And if we've missed the mark here, then we're open for that conversation.
Okay. Thank you. Chairman Welch.
Thank you, Floor Leader Reeves. Question for you. On the language at lines 584, the way I'm reading this is that the individual who may be making the false representation may not be the mother of the child, or the pregnant mother. It could be a third party. It could be a brother, sister, a husband, significant other. So is that the intention? I just want to make sure that I'm understanding that you're talking about someone other than the person who is pregnant, right?
That's correct, and that would also include, in addition to a parent, or it could. I can tell. I'll give you the.
Could it be
some
could
basis.
it be an agent? Could it be someone that's purported to be an agent?
An agent with an agency, or a facilitator, which Georgia does not allow facilitators to engage in placement activities, but other states do. I can tell you where this came from. It was a boyfriend who was acting as the go-between on or making these arrangements for receipt of funds, and he was the only person talking. The mother was deferred everything to him to make those arrangements. And it was a fraudulent situation. So otherwise, that individual would be protected because he wasn't the placing or potential placing parent. But it could certainly be expanded to agency representatives and facilitators, adoption consultants, which I as a being in this field, I'm all for. We want to hold everyone, particularly people that are that are go-betweens of some sort to a pretty high standard.
Okay, I just want to make sure I understood the language and the intent behind it.
Thank you, Chairman Reeves. I'm sorry, Chairman Welch. Okay, so I think we've exhausted at least our today's discussion for the first part of Section 12.
Section 13 is just the conforming all the forms to all of those changes that we've just reviewed.
Okay.
Yeah. Great.
So, members of the committee, as indicated at the beginning, this is just a hearing. Any other questions from members of the committee? Seeing none, Administrative Floor Leader Reeves, Melissa Carter, Justin, I thank you so much. We are adjourned.
Thank you, Madam